Hey everyone, Rick Albert here, and I'm happy to present my first live interview. It is with Mark Oknyansky of the Davidovich-Stein Law Group. He's been a real estate attorney for a long time now, but actually before that, he used to be a broker, just like I am. He actually got his license in 2007, and he used that to help pay for him to go to Loyola Law School. He was the top 10% of his class. Since all of that, he's represented landlords, tenants, contractors, all sorts of disputes. So hopefully you find some really great information here. Don't forget to like and subscribe below, comment, share with your friends, and I will see you at the end. Thanks. Bye. So a couple things. One, we do have the raffle in the back for 1 hour free consultation. So don't forget to sign up. We'll do that at the end. Let's see, what else? One legal disclaimer is everything we're going to be talking about, we're going to be talking about a lot of the new laws, what's going on in the construction world, that sort of deal. A lot of this is general. So if you have something specific, then make sure to consult an attorney because every situation is different. So I just wanted to mention that.
Just to put that in lawyer language,
yes.
Nothing I say is to be considered as legal advice for your specific situation. You can't take it to court, but like I heard an attorney say that. So if you do have specific questions, give me a call. But enjoy this. It's kind of a general guideline.
And of course, if you can't tell by the two cameras, we are recording this. So the format today is going to be, we have a list of questions. We're going to kind of talk, go over some of those questions. And at the end, we are going to do a Q&A. So if you guys have questions, it gives you guys an opportunity to ask. Because who doesn't like free legal advice? That's general.
That is not legal advice.
Okay, so without further ado, might as well get started. So let's talk about the big issue right now. Not issue, the biggest change, which is the statewide rent control. Right, so it's AB 1482. Can you kind of give us a general overview of what's happening?
So to start, there's a lot of laws that just came into effect on January 1st, 2020. The big one that everyone knows about is the Tenant Protection Act. So that one, right, it kind of creates a statewide rent control. You can think of it more of a baseline, kind of a backstop. If there is no rent control in your area, there is now. If there was rent control in your area before, that rent control is still there. So to put that in the context of Los Angeles has a rent control that applies to any building that was built before October of 1978. So if you are renting or you own a building like that, you're still subject to Los Angeles rent control ordinances. The state law didn't change anything for you. If you have a newer building that was built up until I'd say 2005, I think it is. Then now you're subject to the Tenant Protection Act. Any building that is less than 15 years old, you're not within the Tenant Protection Act. So,
And that's a rolling 15 years.
That is a rolling 15 years. So if you were built in 2006 or 2005, I have to do the math, I'm not good at that. But if you're at that 15-year mark, then yeah, it doesn't apply to you until next year. Same thing. If you have a 10-year-old building and in 5 years, you're gonna be subject to the state rent control laws and the Tenant Protection Act. So the next question is, well, what does that mean for me? So if you're in one of those buildings, you weren't within LA rent control before. Here's what's changed. There is now a cap on rent increases. I think most people already know this part of it. The cap is 5% plus local inflation, and local is kind of the key term there. So in Los Angeles today, that would be about 8.3% total between the 5% and the inflation. Just to give an example. And so you can do a rent increase of 8.3%. You're allowed 2 increases per year. So you have to be careful with that. Now, let me take a step back here. 8.3% on top of what? So to figure out what your new rent can be, your maximum rent increase can be, you look at the last 12 months of the rent, and you pick the lowest number, and that's what you increase. And so that's a rolling 12 months again. So you want to kind of plan out your rent increases to make sure that you wait out whatever, if there was maybe a low month there, that you wait that one out, so that's not part of that calculation.
And that's assuming that the lease is ended. So it's not like if you're in the middle of a 1-year lease, you're like 6 months into it, you know what, I'm just going to raise your rent. It doesn't work that way because you're still within the contract.
Correct. I mean, nothing's going to supersede your contract. You look at the rent control laws and say, well, I can do 2 increases a year, if your contract doesn't actually state that you can do that. So first and foremost, you have to follow your contract. Otherwise, you'll have a breach of contract claim on top of your rent control tenant dispute. So that's the big issue.
Can you put increases in the contract and that wouldn't be affected by rent control?
No, you cannot contract around rent control. Like you can't make a contract that says, well, rent control says I could do 2 increases, but you're agreeing to let me do 3. So there's certain laws that you can have somebody waive, and certain laws you cannot have somebody waive. Now, I couldn't tell you as I sit here whether this is one that you can't waive, but I can tell you that the law will probably assume that you can't waive it. If you go in front of a jury and a judge, they'll probably tell you, no, the law says you're just trying to get around rent control. If it was that easy, everybody would do it.
Because in the state of California, we're more of a tenant-friendly state.
Very much
So they're more likely going to side with the tenant, so you're better off side on the air of caution in that respect. So in terms of, LA has their own rent control, but like for example, Burbank didn't. So Burbank then would fall under the statewide rent control, be an example. Okay, so in the city of LA then, what is different than what's with the statewide?
There's one more, before we move to that, there's one more area that any landlord should be aware of, and that's how you can evict a tenant. Has also been regulated by the Tenant Protection Act. You can only evict a tenant for just cause. It used to be you can evict the tenant because you just wanted to make the unit available for maybe make more money or something like that. But now you have to have cause. What does that mean? There's 2 kinds of cause. There's the at-fault cause and not at-fault cause. At fault meaning the tenant did something that either breached the lease, they didn't pay, they got a dog when the lease says they're not supposed to get a dog. The things that breach the material terms of the lease, you can evict them for that. And then the not at fault is if you're going to take the property off the market, or if you're going to move into the property, things like that allow you to repossess your house, basically. Those are called not at fault because the tenant didn't do anything wrong. But you're still allowed to evict them for that purpose. But you have to be aware of some guidelines. You have to give them adequate notice. You have to make sure you're going to have to pay them relocation fees. So anytime you move a tenant out and for a not at fault eviction, you're going to have to pay them about a month. I think, I'm looking at my notes here. It's 1 month of rent
For the state.
For the state.
Yeah, LA's different.
LA's a lot different. To get to your question.
Yeah.
So now we're going to compare and contrast with the city of LA. City of LA is a lot more restrictive than the state. Again, the state was just setting up a backdrop. Like if you don't have rent control, we're making some sort of rent control. It was never intended to replace LA rent control. So what is the difference? LA rent control caps also how much you can increase your rent. And as of 2019, your maximum increase is 4%. So it's a lot lower than the state rent increase. There's the rent control in LA has adopted the state model where you must have just cause to evict a tenant. So that they kind of matched up with the state. So basically, cut to the point there is you still have to have cause to evict the tenant, and you still have to pay them relocation fees if you're moving them out of the unit to either remodel the unit or to basically evict them to repossess the unit. Now, the amount that you're going to pay them in relocation fees is much higher in Los Angeles than it is by the state rules. I actually have the rent stabilization update. So you're looking at spending as much as $11,150 if a tenant's been there for more than 3 years. or qualifies as a low-income person under HUD, or $8,500 if they've been in less than 3 years. Certain qualified tenants can get as much as $21,000 in relocation fees. So, as you see, Los Angeles is a lot more tenant-friendly in that regard.
Yeah. Okay. Yeah, I mean, and a lot of this stuff can be found online. Right?
Yeah, I mean, the nice thing that the city of LA does is they put everything online in a relatively easy to search and easy to find way. They summarize the rules pretty well. You could go to hcidla.lacity.org, or you can just Google Los Angeles RSO, and it will get you to that page. And there's a good summary of what the RSO stands for Rent Stabilization Ordinance, and it'll tell you basically what you can expect in terms of the rules. I mean, in LA, for instance, landlords should know that their security deposit, if they put it in the bank, they're going to pay their tenant interest rate. Some people don't know that. And as of July of 2019, that's 0.06%. It's not a big interest, but you should know that because at the end, you're going to have to pay them something. And it's either that 0.06%, or you have to provide a bank statement and pay them what interest you actually earned on that money. So fun fact.
Yeah, fun fact. Yeah, sure. Okay, so you have a tenant, you don't like them, or either way you want them out.
Mm-hmm.
So I know the eviction process is different, let's say in Ventura County versus LA County. We're currently in LA County, so what is a general overview of that process?
The eviction process is actually similar across counties. What does change is how long it takes. Los Angeles is pretty backlogged. They take a lot. The courts, all the delay happens in the courts, and so the courts take a lot longer to process applications and paperwork in Los Angeles than they do in, say, Ventura County. So that's what the big difference is. But the process would be the same. So somebody, let's take the example that they don't pay, and that's probably the most common one, right? So if they don't pay you, you have to post a notice on their door, 3-day notice to pay or quit. And that notice has to be accurate, meaning if it's a penny over what they actually owe, it's invalid. So you gotta make sure your accounting systems are up to date, you actually know what they owe, and make sure it's accurate. You also have to mail them a copy. It's post and mail. So after, and it's, what changed this year that wasn't applicable last year is it used to be 3 calendar days, now it's 3 court days. So think business days. What effect does that have on you? It just means they have longer now to pay. It's not 3 actual days. It also extends how long it will take to evict that tenant. So that's the first step. So the period of time goes by, they haven't paid, they haven't cured. So then you have to file a lawsuit. It's called an unlawful detainer, and you have to serve it on them. And so normally they have 5 court days to answer a complaint, but that time is extended depending on how you serve them. So if you serve them by physically handing it to them, you get a process server, somebody physically hands it to them, you're good at that 5 court days. But if they're not there, you give it to somebody who isn't the tenant, who happens to be at the property. It's called substituted service. You then still have to mail it to them, and then you get an additional 10 calendar days to respond to that complaint. And if you can't serve somebody, you can't find somebody, then you keep knocking, nobody ever answers the door, then you have to ask the court for permission to post the complaint. So that is another point of delay that you'll see more of a delay in LA County than in Ventura County because you have to go to the court. So in smaller counties, more efficient counties, sometimes you could go in the same day and get that permission. It's generally routinely granted. In LA County, it could take 5 to 10 days to get that back. So just budget that into your time and how long it's going to take to evict that tenant. Once that time period has gone by, there's one of 2 things that can happen. They either answer the complaint or they don't. If they answer, then you've got a litigation going on. You have to do discovery, ask them questions, they could ask you questions, and then there's going to be a trial. 99% of those get settled, and I'll talk about that in a little bit. The other way, and actually what happens most often, is you don't get a response at all. Then you go to the court, you file a default judgment, which basically tells the court, I did everything I was supposed to do to serve this thing, they didn't respond, please give me judgment so I could evict this tenant. You'll probably get it. And then you have to file a writ of attachment, or a writ, sorry. And that just gives you the legal right to now take possession of the unit. You can't take possession of the unit. You have to call the sheriff's department and schedule what's called a lockout. Once you do that, the sheriff's, you send everything, the writ, the judgment to the sheriff's office. They give you a date. And that's the date where the sheriff is going to come in and give you back your unit. They're going to evict anyone that's in there, unlock it, and it's yours. So that's the general process. Now, I said I was going to come back to the settlement part of it. When they do respond, they'll usually take it to the day of trial, the tenant will, and then that's when there's a couple different ways that this resolves. It's either it's something called a pay and stay, meaning they pay the past due rent and they get to stay. That happens a lot. Or a move out. So they basically just want you to let them move out, and they'll just leave peacefully. Sometimes what they'll ask, and something that's kind of a key tool in the lawyer's arsenal here, is sometimes they want the record sealed. They don't want the eviction on their record, so that it doesn't affect their ability to get a unit later.
So if they try to rent another place, they don't want that on their...
Exactly. And so in those cases, they'll ask for that. I know a lot of times landlords are like, well, this tenant, really screwed me over. And they were just really bad. And so I want it to be on the record. But you got to remember, it's a business decision. This is a business you're running. So if it gets them out, just by sealing the record, get them out. It's better than fighting with the bad tenant.
So I know, I've talked to a lot of people and they get scared by this whole process, the whole eviction, I don't want to deal with it. How do I avoid it? And it really comes down to the screening of the tenant from the get-go, right? Looking at all the documents, all that kind of stuff. What is ways to protect yourself from those bad tenants as they start the application process?
It's a great question. So now that rent control is everywhere in California, it's really important to make sure that you get a good tenant. And you have to be diligent. It's easy to be lazy. I talked to that guy and he seems really trustworthy. Or it's a family.
Great personality.
Great personality. Those are all subjective. But you need objective facts. You need to get their pay stubs, tax records. You can ask them for anything that you need to ensure that you're comfortable with that person, that you think they're going to pay you back. One thing you cannot look at now, which is a new law this year, you cannot look at the source of the income. So that's something new. You used to be able to say, well, where's this money coming from? You can't do that now. That's more meant to protect Section 8 people, low-income folks, because they were being excluded from rentals. They were coming in, and people would see that they're getting government assistance, and they'd be like, I don't want to deal with that. Well, you can't do that anymore. So now you can verify their income, but you can't verify where they came from. I mean, you could, but you can't judge their tenancy based on that.
So going off of that, if let's say, because you look at their bank statements and you see consistent deposits being made of the same amount, and you want to make sure that that matches with the pay stub that they're claiming to get income, you're saying you can't look at those pay stubs, or you can?
Look,
because if it's Section 8, then it'd be part pay stubs, part the other government money.
if somebody is coming in with Section 8, they'll probably tell you.
Yeah, 'cause the unit has to be approved for Section 8 anyways.
Exactly. So, I mean, you can verify, they can tell you the Section 8, but how Section 8 works is they get a voucher that says how much the government's going to pay for their unit. So yeah, you can ask them for that information to make sure that they're getting enough money, and then what you're really judging is how much money they're making outside of that voucher to make up the rent that you're charging. So you can't discriminate based on the fact that they're getting Section 8 payments, but you can look and say, well, is he making enough money outside of this voucher to bring him up to this level?
So what I've been seeing a lot of with a lot of my clients, even some of the rentals that I have when I get applications in is if let's say they had a bankruptcy, and nobody's perfect. If everyone was perfect, had lots of money in the bank, they'd probably buy. So if we get this paperwork in, it says there was a bankruptcy 5 years ago, 7 years ago, and they say, well, I can explain it was because of a medical condition I had, it basically went way out of hand, or I went through a divorce. What can we ask for as landlords to verify that that information is true?
And it kind of goes back to what I said earlier. You need to ask for whatever documentation is going to show that they're making the money that they say they're making. So yeah, they might have had that bankruptcy. So ask for paycheck stubs. Ask for, if they're independent contractors, for instance, ask for the 1099 for the last couple of years. The tax records. But also ask for evidence of their debt. Ask them what kind of debts they have. How are they paying that kind of thing. So somebody has child support or alimony, that would likely be on the tax report, the tax filings. But you can ask them, because you have to be comfortable. So if their debt to income is too high, if there's some credibility issue like a recent bankruptcy, then ask them for more information to make yourself happy that they can actually afford. Now, don't go discriminating. Don't go looking for a reason to get rid of this guy or this family or wherever it is because they had the bankruptcy. Just ask them for additional documentation
To kind of support what they're saying.
to support what they're saying, or to support your decision not to rent to them. But just be clear and be as non-discriminatory as possible. And that's kind of the key in California is make sure you're being objective. Don't be subjective. And that's when you get into discrimination. Be objective. Make sure you're looking at the numbers. Make sure you're looking at the actual facts, and the facts you're allowed to look at. And I'm referring, of course, to where the money's coming from, Section 8, or maybe this guy earns cash, things like that. So
That makes sense. So
do your due diligence.
Right. So going along the lines of discrimination, we have a lot of people I know here in the audience that are really interested in house hacking, which is buying a place and renting out bedrooms. If it's a whole other unit, I kind of get it. You can't really discriminate. But if it's your own house, maybe you don't feel comfortable with the opposite gender being in the same. What kind of laws are protecting that when the landlord is actually living in the same residence, if any?
Right. So that's a good question as well, because you can't discriminate based on gender or race or national origin, things like that. So, but when you're looking for essentially a roommate, you call it house hacking. You're essentially talking about a roommate.
Right.
And so you're allowed to interview people and make sure their personalities fit and make sure they mesh with you, and that you can live with that person. So you can't discriminate because you're renting to a woman, but you can say, this is my house and I just don't feel comfortable with this person. It's not discrimination, it's more they don't mesh with me, because I live here. And so you're allowed to do that.
Yeah.
We're getting confirmation from my realtor friend over here.
Okay.
Did that answer the question?
Yes, it did. Thank you. And this is more of your opinion, just because I'm curious, because many people, we all have opinions. Is this actually protecting tenants? When we talk about these new laws, on the surface it sounds like it does, but then we just talked about how landlords have to get more specific as to who they pick now because the process has changed. So do you actually think this is actually going to help tenants?
Well, it's called the Tenant Protection Act, right? So it must be protecting the tenant. Now, it is protecting tenants in a lot of ways. It's protecting them from absurd rent increase. Like we saw in San Francisco, because of the big boom due to Google and all the tech companies, rent increases of 500%. It's crazy stuff. So it really puts a stop to that kind of thing. Maybe not San Francisco, because the rent control is probably worse than LA's rent control, but the areas surrounding that. So it does help tenants. It does protect them. It does prevent evictions just for profit, that kind of stuff. And so ultimately, yeah, there's a lot of protections for tenants who weren't otherwise protected by other rent control laws. However, there's also a flip side to that. It disincentivizes people from becoming landlords, which takes units off the market. it also does incentivize those landlords still in the market from maximizing their rent increases. You only get 2 a year, and it's based on the lowest rent collected in the last 12 months. So, to preserve your right to get higher rent, you're going to increase the rent where maybe otherwise, without that pressure, you might have allowed another year at the same rent. So you're going to see a lot less mom and dad landlord and a lot more corporate landlord, I think, because they're the ones who can take that risk, that have the funds to go through the eviction process, that have the patience.
And we've seen in other industries as well.
Yeah.
There's been more regulation, like with the Dodd-Frank for mortgages. A lot of the smaller banks couldn't afford to keep up with all the compliance, so they closed up shop. So it might be some of that similar situation that might happen here.
Exactly. That's a very good point. It's going to be like anytime you introduce regulation into the industry, regulation comes with a cost. And the cost can be borne by corporations because they have the scale to eat that kind of cost, but mom and pop can't. So you will see, I think, an exodus of some mom and pop. Now, something we haven't talked about, and that's ADUs. So where do normal people who own a house who want to rent out a piece of their property come in?
And just so everyone knows, for those who don't know, ADUs are accessory dwelling units. So that's a conversion of your garage is the most common one, but some people actually section off houses, basically adding a second unit to your property, just so we're all on the same page.
So where California taketh, California giveth. So because we have such a housing crisis in this state, you see a large swath of laws that just came into effect that allow developers to do things they couldn't do before. You can shortcut SECA, and SECA is California's environmental laws. There used to be parking restrictions. You have to have enough parking for the people living in your building. It makes sense, but you don't have to do that anymore. You still have to have parking, but the restrictions are a lot lighter. If you own a house, you can actually build a second house on your property, and now the government only has 60 days to approve it. It used to be 120 days, so they cut it in half, the approval times. And you have 2. So now if you own a property, you can take your garage, and you can create what's called a junior ADU, which can not exceed 500 square feet, but you can rent that out, and then you can actually build another structure on your property, even brand new, or you can take one that's already there. And that could be up to basically 16 feet tall. You could build a 2-story, 800 square foot or 1,000 square foot property on your lot and rent that out as a second ADU.
If you're doing junior ADU, aren't you limited to 800 square feet? No, I mean for the main ADU.
For the main ADU, it's 800 or 1,000. I think it depends on how many bedrooms.
Attached. So yeah, if it's attached ADU, if it's attached to the house, no more than 800 square feet. If you're going to do 2 bedrooms, then you can bump it out to 1,000. If it's detached, I believe the law still applies to a max of 1,200 square feet.
And you can still do junior of 500 as well.
Correct.
So 1,200 and 500?
Correct. But the junior ADU, just so everyone's on the same page, the property itself has to still be owner occupied. So it's not like you can move out and now you have a triplex. You have to still live on the property in order for the junior ADU to be in effect.
To confuse people a little bit, I'm laughing a little because to confuse people a little more, California has that owner-occupied requirement. It doesn't exist actually for the next 5 years. California kind of gave a 5-year grace period for rent. You can rent your main house and your ADUs. You don't have to live in it for the next 5 years. The city, the county, they cannot require you to live in it. That used to be the rule.
Okay.
But from now until 2025, that restriction doesn't exist. We're going to do a Q&A at the end, but go ahead.
So let's just say it's 5 years from now. Can I rent, say I don't want to live anymore, can I rent the whole thing out to one individual? They want the house and the ADU?
Sure. It's your property. You can rent it out however you see
but
fit.
just not 2 separate leases, 2 different tenants.
And now, if you already have 2 tenants in there and you have to evict one to make that happen, that's a different story. But if maybe that tenant moved out of one ADU and now the main house tenant wants the whole property, you can negotiate that. Yeah.
So we talked about a little bit about the tenant protection. Let's talk about landlord. Is there anything in addition to basically creating policies, right? We want to create policies and procedures for all your rentals. So then you can even go to tenants and just say, hey, look, I'm sorry, it's per our policy, this is what we're doing. And also better screening from tenants. Is there anything else that landlords should be watching out for, anything they should be doing to better protect themselves?
Well, I think at least once a year, probably more. Any landlord should be, especially in Los Angeles, if you're under LA rent control, you should be checking into that website, that SID website, and seeing what's new, because they publish a rent stabilization ordinance update every July. And it's in effect from July till June of the next year. So you should be keeping tabs on it, because by law you're deemed to know what the law is. If you know, it's always wise to have a relationship with an attorney. Anytime you're in a business in general, and this is a business, you should have a relationship with an attorney you trust that you can ask questions of. Most of the time, they'll give you the updates anyway. Like most of them won't charge you to just tell you what changed. But things like 3-day notices, a lot of people do it themselves, but we run into people who do it wrong all the time. They come to us, they ask us to do an eviction, and we look at the 3-day notice and say, well, this is wrong. We have to start over. Not a big deal, but now you've lost that time period. You're not making money in that time. So I think it's good to have a relationship with an attorney. You can even pay them to draft a model 3-day notice, and then you can just use it forever or until the law changes, and then you have to update it. And just you could do that part yourself. And if they don't pay, or if they don't cure, like they breached a part of the lease, if they don't cure, you can hire their attorney to do the unlawful detainer action and take it from there.
Okay, that's all really good. Thank you for that. So let's kind of switch gears a little bit and go into the construction side, because we have a lot of people here who are building out ADUs, or they're even sectioning off part of their houses, maybe adding another bedroom so that way they get more rent, that sort of deal. From a legal standpoint, what should we be looking for in contractors? Because there's so many out there.
There's a lot of contractors, and it is very difficult to find one that you can trust. I mean, the safe route is always to look for somebody who's licensed, because people licensed by the state of California have to carry a bond. So if they mess up the job, you have a source of money to go that doesn't rely on their bank account. Contractors, they can change their corporation name, and all of a sudden you have no one to sue. So a licensed contractor is going to have insurance. They're going to have workers' comp insurance. They're going to have a bond. So if they do mess up, it's like an insurance plan for you. Yeah. Then you want to make sure that you have a good contract with your contractor that protects you. You want to make sure that the contract clearly states when payments are due, and at what stage of the construction, what happens if they're not on time, what happens if you make a change, things like that. So, and if you get a contractor who's pushing back on some common sense changes, find a new contractor. Like you said, there's a lot of contractors out there.
Right.
But the main thing is the relationship with the contractor is purely contractual. So make sure that your contract says what you want it to say. Then I always ask for certificates of insurance just to verify what they have. Look them up on the CSLB, California State Licensing Board, or something like that. Just like you do with a tenant, do due diligence about your contract, because it is a relationship that can become very expensive if you don't pick the right one.
Oh yeah, I've seen that many times. I mean, what have been some of the big issues with contractors? Like in terms of lawsuits, things like that, what's been the biggest issue?
So generally when somebody comes to me, it's because a contractor didn't finish the job, or they did a bad job, and so you get into a lawsuit. It's a breach of contract claim, and so you're looking at damages that perhaps you had to hire a new contractor to do the job, and it cost you more money. So your damage would be the difference in the cost. There's also damages that people sue for that include carrying costs. So say you had a contract that says the contract is supposed to be done in April, now it's September and you have to hire somebody else to do it. The job's done in September. Well, you've now, especially on a rental, for instance, you know how much income you're supposed to get from rent, so you could calculate that. And so your damages would be that, I had to pay this amount in my mortgage, and other carrying costs that go, taxes, things like that. And plus now I have to pay an extra, $50,000 to get the same work done. Well, that would be your damages. And so when they come to us, it's mostly just, again, that's why the contract with your contractor is so important. It makes our job a little easier. We get a lot of people who don't have a good contract. It was a handshake, it was a scribble on a piece of paper, and then it's like, well, what terms did you actually agree to? Now you've got a he said, she said situation.
Sorry, I'm laughing because I've heard this story before.
Exactly, and it happens a lot.
It happens all the
a lot.
time.
Sometimes people hire unlicensed contractors. Oh, in the state of California, it really sucks for the unlicensed contractor because unlicensed contractors, you don't have to pay them. There are some equitable kind of remedies, like you did some work and maybe no. California says we want you to be a licensed contractor, and if you do work knowing you're not licensed, you're not going to get paid for it. Even if you've already paid them, you could sue them and get it back. It's that harsh. It's really harsh. I've seen it happen. It's kind of a sad situation for the contractor. Sometimes, a lot of times they don't get licensed because it costs money to get that insurance. It costs money to run a business like that. And so it could be pretty sad. But at the same time, some of these unlicensed contractors could be fraudsters. It could be people who are just trying to take advantage of you, and so you're protected that way.
So that's an interesting point, because if they're licensed and all that, but then they finish the work, what kind of warranties, right? Because I know with new construction, there's the 10-year warranty. First year is what's called fit and finish, right? Bumper to bumper, and then it's systems at different stages. Just what applies for just remodels? If I just remodel my house, what happens?
Okay, so what you're referring to, California has a backdrop of warranty. So usually when you buy anything new, there's a warranty, including a house. So you get a house built from the ground up from a developer or anything like that. It's going to come with various warranties ranging from 1 year to 10 years, depending on what part of the house you're talking about. A lot of times those builders also give you a contractual warranty, kind of a bumper to bumper, like you said, warranty on the appliances, everything like that for 1 year. It's a limited warranty. With remodels and other construction jobs, there isn't really a California law that protects you. There isn't like a default warranty. What you do have, though, are implied warranties. California allows you to sue based on an implied warranty of good faith and fair dealing, for instance. You contracted, to build like a 500 square foot addition, and they lied to you about some aspect of it. That would be a breach of good faith. Or they built it in such a way that you couldn't use it. I'm trying to think of an example, but basically they did something in a contract that defeated the purpose of the contract. Then they would be breaching that good faith. They're not acting in good faith. There's also, good faith warranty of fitness for a particular purpose. So rather than using housing, I'll use shoes. Like you go into a shoe store and you tell the guy, I want running shoes, but he sells you bowling shoes. Well, but tells you they're running shoes. Well, he's breached that warranty. So that's just to give you a kind of a basic example. Now, those are not very strong warranties. They're subjective. They're going to argue. You're going to have a big lawsuit and case and go to trial on it potentially. So what you want to do to protect yourself is make sure the warranties are in the contracts. So again, it all comes back to what your contract is with the contractor. Make sure that they're warranting their work for a certain period of time, just like you would when you go to an auto mechanic. They rebuild your engine, you want at least a 1 year or 2 year warranty to make sure they did it right. So if there's something wrong, you can go back to them and they can fix it. Same thing with a contractor. If they're building a kitchen for you, make sure that their work is warranted for however long, I would say at least a year. Just to, especially if you're doing things like plumbing, because problems with that can come up, and they're expensive to fix. So again, it's a part of the negotiation process with the contractor.
And part of the reason why I asked that is because in this audience and other people that might be watching, they're really interested, because of HGTV, they're really interested in flipping houses. And so that's kind of why I want to talk about it, because for some flippers, if the work's done and then the buyer says, oh, there's issues, we want to know kind of where they stand. So it's more like if the flipper isn't the contractor themselves, they can possibly go back to the contractor, or is it once it changes hands, we're kind of done? Like the contractor is no longer responsible.
So, are you talking about when you're selling the house? You've bought the home in a kind of a bad condition, and you fix it, and then you flip it, so you sell it to a new buyer.
Yeah.
And so the question is, what can that new buyer do?
Correct.
Okay. So the new buyer, if there's a problem with the house, they're going to come after the seller, the flipper.
Right.
And they're not going to come after your contractor.
Sure.
The person flipping the house, the seller, would of course be able to sue their contractors if there really was something wrong with the house, based on the work they're supposed to do. They would have a different cause of action, but the seller would still be liable to the buyer potentially for those defects, to the extent that they'll represent it. Like you're selling a house and you say, here's a list of everything we fixed. Excuse me, and they come back and say, well, you said that you completely remodeled and replumbed the bathroom, for instance, and it's leaking all over the place. Tiles are falling off. You lied to me. This is not a new bathroom. So then you could sue the seller, assuming you relied, and that's why you bought the house, is because it's so remodeled. And then the seller's remedy, of course, would be to go back to his contractor and say, hey, you got to fix this.
Okay, that makes sense, because in the state of California, we're definitely a buyer beware state. So buyers are going to come in and do their own inspections. I just had a client recently buy a house that was a flip, and we did inspections, and there were a bunch of issues. So we had to kind of go back and forth with the seller, what they were willing to do, not willing to do. But in terms of warranties, just so we're on the same page, really the seller's only on the hook for the work that was done, potentially, right? Because of what the contract. So like, for example, if they never replaced the roof, the seller, as a flipper, you're not responsible for that roof because you didn't touch the roof. So if there's a roof leak, things like that, is that kind of along the right lines, or? Yeah,
it is, and I could kind of boil that down to a maxim, and that's, you got to disclose what you know. You don't have to disclose what you don't know. The only caveat to that is you have to disclose what you could have known or should have known. Rick's right. This is a buyer beware state. You buy things as is. You look at, if you're a realtor, you see listings all day long that say, buyer to do inspections, sold as is. That's fine, and you can do that. And what that does is shifts the responsibility to the buyer to make sure the house doesn't have any problems with it, avail themselves of inspections, do whatever they want. You have to allow them to do it. I've seen situations where they say, we're selling this as is, but they wouldn't let the inspectors in until like the close of escrow, basically, and then they find a bunch of problems. So you don't want to do that, but you want to make the home available to inspect, and that's another, if you're a flipper, you're flipping that house, you can tell them, well, here's what we fixed, here's what we did, but we still want you to inspect it and make sure that it, that you're satisfied that we did a good job, and that's fine. What's not fine is if the seller knows that the plumbing in the sink leaks, or the toilet keeps clogging up, and they don't say anything about it. So you can't tell somebody to take on a liability to take a house as is if you're hiding something that's wrong with it and hoping they don't figure it out before the escrow closes. And that's basically what happens. You know there's a problem, and you're just waiting it out. They bought it. I'm free and clear. I'm out of here. I got my money. Well, it doesn't work that way.
Can the quitclaim deed protect the seller from something?
Quitclaim deeds can. So we're getting a different topic with that, and why don't we come back to that in Q&A?
Yeah, I'll make a note of it.
Yeah, I'll talk about that. So it comes back to what I started with: is disclose what you know or what you reasonably should have known, and always just tell them. So if there was a plumbing defect and you fixed it, even say there was a plumbing defect, you get something called a transfer disclosure statement, and you also seller's advice.
Property questionnaire.
Seller's property questionnaire.
Yes.
And it's basically a bunch of lines pre-filled in. You just check boxes, and when you check this, so plumbing is up there. Like you repaired plumbing within the last year, you have to check if you did. You have to check yes, and then there's a line for you to explain what happened. You have to be truthful in this. Not answering truthfully is considered fraud.
Has that been the biggest? What has been the biggest reason for losses? Is it because of those disclosures for flippers, like in terms of?
Well, I'm not talking specifically about flippers. I mean,
Or just in
if you're a
general.
flipper, you're still selling the house.
Yeah.
So this kind of applies to everyone who sells a piece of property, residential property, I should say. The law wants you to tell the truth about what you know, and so they give you these forms so that you can tell that. Where somebody who is flipping a property is a little different than the average buyer. A lot of times they've never lived in the house, and so you really can only know what you've seen by walking through it. And so I've seen disclosures, and I think they'd be effective. I haven't tested them in court yet, but a disclosure where seller has never lived in the house, seller has not has never inspected the roof, for instance, never done this, never done that. That's still a disclosure. You're still telling them what you did, and you're being honest with the buyer, and you're saying you, buyer, have to go make sure that those systems work for you. That won't prevent lawsuits, because it'll prevent lawsuits from reasonable people. But a lot of times there's a roof leak, and they still want to sue the seller. So it won't stop ridiculous lawsuits. But at least you'll have a defense, a piece of paper you could go back to that says, I told them I never looked at the roof, and told them they should look at the roof, and they didn't. So by law, you'd be, theoretically, you'd be, not liable for that roof leak. I say theoretically because when you go to trial, anything can happen. Whether it's a jury, especially with a jury, because you got 12 people, and you got 2 lawyers or more telling those 12 people what to think, and they don't. They're supposed to follow the law, but they're interpreting facts. Sometimes they interpret facts in a way that you just never intended for them to interpret. So anytime you go to litigation, you just have to be aware of that kind of risk. For that reason, 90% of our cases settle because nobody wants to take that risk on either side of the aisle. So it's much safer to find a reasonable number where everyone's just happy or everyone's upset, however you want to look at it, and settling the case. But that only happens when you've got a reasonable lawsuit. If there really was something, the seller really knew that there was a plumbing defect and didn't say anything, and so the job there is just finding what's that worth to both parties. In fact, a lot of people don't know, when you sign a residential purchase agreement, there is a mediation provision in there, and so you have to go to mediation, or you waive your right to attorney's fees. Attorney's fees in California, you only get them if it's in a contract. And it is in the resident. If you use the CAR form, the California Association of Realtors, it's a pre-printed form. You just fill in the blanks. If you use that form, there is a provision to allow you to get your attorney's fees if you have to sue to enforce that agreement. And right at the outset, you have to offer mediation. You have to go to a neutral third party, and you have to write down the issues, write down your defenses. It's almost like a mini trial, but there's no judge. And that neutral person goes between the parties, tries to figure out how they can resolve this before it gets any further. And it works. I've had at least like 3 or 4 cases come through where we get to that mediation stage, and everyone just figures out, it's going to cost me $100,000 to go to trial. Let's figure this out. And so they do it at that mediation. Because that neutral third party is usually either a former judge or an attorney who's been doing it for a long time, and they know, and they kind of scare both sides, so to speak. They don't scare them, but they tell them what the negative parts of their case are, and what could happen if they go to trial, and that usually pushes the parties to say, okay, well, I guess I should have said this, and I didn't, and it cost them this much. Let's meet halfway, or whatever's reasonable, and so normally those do resolve.
So rolling back a little bit, just so, because one of the developers I work with, what they tend to do to protect themselves is actually we call it a list of improvements, and it's actually part of the marketing. So we just say, hey, here's all the work that's been done. So should something bad happen, let's say we never touched the roof, they come back and say, oh, there was a roof leak. It's like, well, you received the list of improvements, and nowhere on there did we say we would replace the roof. Would something like that work?
Yeah,
Or should I say, would it help your defense? Because again, like you said,
Yeah.
once you're in trial, anything's possible.
Right. It would help. It would
Yeah.
help because anytime you write something down on paper, it helps to show what you intended. Where you get in trouble is where some term wasn't defined in the contract. So if you are a seller and you only touch certain parts of the house and you never lived in it, you create a form like that. And it says, the seller has never lived in this house. It is not their primary residence. They don't know anything about the house except this. And then you disclose, we remodeled this, we did this, we did this, we didn't touch the plumbing, we didn't touch the roof. And so buyer, we are selling it as is, where is, and outside of these things, you have to inspect. You even have to inspect the stuff we're telling you, but you can't come back to us about the stuff, especially that we didn't touch. Again, it goes back to this being a buyer beware state. You're buying something, you have to do the work, the due diligence to make sure that it works for you and that there's not a problem.
This has all been amazing. Thank you so much for this. Was there anything else that you want to talk about before we open it up for Q&A?
I think let's take a step back. So the state of California is kind of an oxymoron right now, and I say that because you've got really restrictive rent control coming in, but at the same time, you've got huge opportunities that didn't exist before in terms of development and construction. You could take a piece of dirt anywhere in the state of California now and put multiple units on it. Infill development is being heavily pushed by our laws. So I went and tried to figure out how many laws came into effect, and I printed out a 7-page document here that basically says, here's all the laws. It basically, it doesn't define the laws. It just gives you a bullet point. Here's what the law does, and as you can see here, it's 7 pages of different laws. So what does this mean? If you're an investor,
Job security for attorneys?
yes, exactly. Yeah, definitely. There's a lot new, and there's a lot that hasn't been tested in courts. So how the law works is the legislator writes them, but they never write them perfectly. They don't capture every little detail, every scenario that could come up. So you always want to run things by attorneys, and even that's not foolproof. You hire a consultant, they say that it's okay, and it might be at that moment until it gets in front of a judge, and then the judge says, well, no, that's not okay. So, there's a lot of volatility because it's so new. There's not a lot of case law we can fall back on. There is case law we can fall back on in general in terms of rent control, or in terms of interpreting what the legislature meant, things like that. But be prepared for a little bit of volatility. But there's a lot of opportunity to go and build things and skip a lot of the regulations that used to prevent you from building. The state of California has told the cities and the counties in the state now, by the laws, that they cannot downzone a piece of property. They can make it's just called density. How many people per acre, or how many people can live in a given area of land? It's called density. And so the state has incentivized increased density, especially around metro stops, bus stops, train stops, anything like that. So anything within a half mile of that, you don't even have to, parking is going to be a lot easier because you don't have to even worry about getting everybody parking, like I said, if you're within a half mile of public transportation. They increased the definition of what is a major public transportation. So the state has done a lot to make sure builders will go out there and actually build these units. And you don't have to go through as many of the environmental regulations. It's all fast tracked, so there's strict time limits now on how long the government has to approve things. So you think of California as this really environmentally conscious state, and it is. But now, because of the housing crisis, it's cut back a lot of that. So it is a good time to actually get out there and build. obviously, the point is to get more people in units. There's more people in the state of California than there are housing units, and that's a problem. And so the state of California is basically paying you almost in terms of easy regulations, fast track status, to get that done. So if you are looking, if you are an investor, it's a good time to do that, especially within this next 5 years.
All right, so why don't we open it up to the Q&A? We'll start with you because you had a question about the quick claim deed.
Yeah, so what quick claim deed can protect, let's say somebody is selling an old house and he says, here, it's an old house, so I don't know, it might be bad, but he knows about some issue where there is a, I don't know, gas station underneath there or something.
Yeah.
So to recap, just to make sure it's on
So
the...
he's hiding something, but still agree.
Right. So the
wants
question
to do a
is,
quick claim because something
Right.
else seemingly bad, but he hides the main thing.
yeah. So the question is, can you get around the disclosure requirements by using a quick claim deed instead of a grant deed? Now, before I answer the question, let me explain what that means. When you transfer a piece of property, you use a deed. Normally in California, it's a grant deed, and that carries certain warranties about the property. A quick claim deed has no warranties. You usually use a grant deed when you're transferring a property to someone you don't know. You're selling it, things like that. Quick claim deeds are more often used amongst family members or business. Say you have a piece of property and you have an LLC, you transfer it to LLC, you use probably a quick claim deed for that. So your question is, can you use that quick claim deed to get around disclosure? And I think the answer is no. And I say I think because you never know. But the point is, if you're hiding something, the state of California says you're committing a fraud. It's a fraud. I mean, it's just the very definition of fraud. You know a material fact. Somebody is buying a piece of property based on your representation that material fact doesn't exist. Silence is a response. You're saying something when you're being silent, and you're saying that condition that you know about doesn't exist. If you know that there's a big problem, a quick claim deed is not going to solve the disclosure requirement. You're still committing a fraud essentially by hiding it.
So you should never buy anything, even like a house in a bad shape that you're going to flip anyway, with a quick claim deed, right?
I mean, you could, but it doesn't. You should still do your due diligence about what is going on with that house. You should still do your due diligence about just how bad that house is. I mean, just because the house is in decrepit condition, you still want to make sure that there's not a zoning issue, there's not a tax issue. You still want to do your due diligence. When you buy it, you want a grant deed because you want to make sure you can come back if something's wrong.
And I've heard of lawsuits where because even though you do a quick claim deed, correct me if I'm wrong, at one point you were still an owner, so they could still come after you and say, well, you didn't disclose it to the. Let's say you try to sue the current seller, but you can also go after the previous seller because the seller didn't disclose it to the current seller.
I think this will clarify it. The type of deed you use only applies to the title. You're warranting the title of the house, not the condition of the house. So a grant deed, you're basically saying that I have the power to give you this title to the house. You're basically saying that it's free and clear, or you've disclosed what's wrong, encumbering your title. So that's what you want a grant deed. You want to make sure you're actually buying the house. A quick claim deed makes no warranty about the condition of the title. So title is kind of this ethereal thing. It's not a physical thing. It just it's created by laws. So I think that's where the confusion is. It has nothing to do with the state of the house, the physical attributes of the house.
All right, so you have another question right there?
So your question is, does the new rent control law affect what happens after a tenant moves out? And the answer is no. It actually expressly states that you can rent it for market rent. Actually, I don't know if it expressly states that, but it doesn't limit it. So yeah, you can put it back to market rent. That's the state of California's, the Tenant Protection Act. Now, again, you have to know where your building is and if it's subject to rent control, where it is. And so then you have to look at your local ordinance on that.
But that's where it kind of becomes a business decision in terms of the relocation fees.
I think, well, yeah.
Right, because you might want to pay that if it means that you can increase rent by so much. You might be able to make up some of that relocation fees.
Right.
Got it.
If they just moved out, then there's no relocation fees.
Sure.
You can re-rent it at market rent, pursuant to the tenant protection.
Right.
Yes.
In the trustee sale, you always see they say free and clear. You have given free and clear renting. But on another page, there is a whole bunch of voluntary and involuntary leaves.
Okay.
What does that mean?
So the question is, in a trust sale, where they advertise the property to be free and clear, but then when you look through the property documents, there's a document that has a bunch of encumbrances. And encumbrances are things that cloud the title, or uses that you've given permission to other people to use on the property. So generally when you're buying something like that, you might be referring to a title report. And a title report kind of tells you all the things that affect the title to your property. Who has rights against the property. And those are called encumbrances in that law. When you buy things at auction, tax sale, trustee sale, usually there's no warranties made about whether there's a mortgage that somebody didn't pay, or there's a tax lien on it, or some lien on it. You want to make sure you do your due diligence on those as well. If they're advertising that it's free and clear, it's usually the people running the trust sale is a professional company, so you can rely on that. Those things that you're referring to that you see on that page are easements, for instance. Like the utilities will have an easement so that they can come on your property and make sure, check your meters or things like that. It could have there could be a lien. It could be disclosing a lien that maybe. All of that, anything recorded against that property would be on that page. So you definitely want to pay attention to what's stated in the title report, because you're buying it. You're buying all those properties.
Okay, so when they say free and clear, it doesn't mean you're getting free and clear of all those things.
Free and clear should mean that there's no loans against the property.
Usually it does.
It usually means that. And it usually means there's no tax liens, means there's things like that. So it should mean that there's nobody that's going to come to you and say, you need to pay me now. But still, read all the documents, make sure that the other things don't contradict that free and clear. And if it does, ask them, like, why does it say that there's a mechanics lien? Why does it say that there's a tax lien? Yes, in the back.
Is there a specific statute of limitations for something I may find? Like, let's say the seller didn't disclose and I find it after the purchase. Is it specific to, like, let's say he didn't disclose the roof versus like he didn't disclose a plumbing problem? Is the statute the same across the board?
No, it varies on, like, fraud, for instance, and breach of contract. You have 4 years, I believe.
We're talking about the statute of limitations.
Statute of limitations
Yeah,
means
so we can-
how much time you have to file a lawsuit from I want to say from when you found out about the defect, but it depends on what, because sometimes it could be, from when you bought the house. And so a lot of times when you're talking about fraud, it's from like the discovery of the fraud. Yeah, did that answer your question?
Is that
Yeah, I mean, so there might be some wiggle room, for example, if I found something kind of leaking.
I would suggest if you found something, call an attorney right away just to make sure, and they can look up the law, because there are different statute of limitations for different causes of action, and for different defects. So just call an attorney, tell them what's going on. They will, if they're a good attorney, they won't just tell you. They'll actually look it up and then just verify that that's what it is.
So, real quick. So, in terms of finding a good attorney, what's just real quick for like maybe like a minute? What is something they should be looking for in an attorney?
Well, you want an attorney that you can trust. I mean, they have a fiduciary relationship. They have an attorney-client privilege. You can in California fire your attorney at any time. But you don't want to deal with that, especially if you're the ones making the lawsuit. If you're doing a contingency fee kind of case, you can fire that attorney and go to someone else, but that first attorney is going to have a lien on your recovery now. What does that mean? That means they're entitled to get paid for the work that they did, because contingency fee means that you don't actually pay them anything until you only pay them once you win, if you win. So they will now have a lien on your recovery, so they can get paid still. So it's good to make sure you interview your attorneys, ask them the questions, and make sure they're giving you good answers. I know it's hard to do if you're not versed in the area of law that you're talking about, but talk to multiple attorneys and see how their answer is different. Look them up online. Check their website. Go on Facebook. But always talk. Sit face to face, talk to them, and get a sense. Do I get along with this? It's a relationship. Do I get along with this attorney? Do I feel comfortable with this attorney? Because you're going to have to rely on them. And then once you do hire an attorney, please work with your attorney. Get them the documents when they ask for them.
plea, right?
Yeah. No, we get so many clients where it's like, we need these documents. Well, why do you need these documents? Don't ask that question. We can tell you. Give the documents first and then ask the question. Because usually if an attorney's asking for something, they need it for a specific reason. So make sure you help your attorney help you. If you're suing somebody on an hourly rate, you can expect to pay a retainer. Retainer means you're giving like a lump sum of money up front. That doesn't mean you're paying them that money. What it means is you're giving them a deposit, and it sits in a client trust account, and they still bill like they would if you're just paying them hourly. They still bill, but they just collect from that pool of money until it's depleted. That's an insurance policy for both parties, because for you don't want to run out of money when you need it most, and then now you can't pay them, and your attorney says, well, I'm going to sub out. I'm going to quit, basically. You don't want that. So having that retainer ensures that the money is there for the attorney. It's like a car. It doesn't run without the fuel. And lawsuits are very expensive, and not all law firms can afford to just comp your lawsuit. Like I said, it could be six figures to go from the start to trial. Most of that comes at the time of trial. So again, when your attorney says, hey, they're offering this, think about it. Put your emotions aside and really think about whether that's a good settlement. They're only going to, your attorney will tell you if it's reasonable or something like that, and they'll tell you the pros and cons of it, and don't be afraid to ask. But really consider it, because the biggest cost comes when you're getting ready for trial. Everything before that, it's kind of reasonable, you really hit the gas pedal. The attorney's working a lot of hours to get ready for trial. And hours on a billable rate kind of a deal, means money from you. So just talk about a litigation strategy with your attorneys. What are the different options? How can we end this sooner? If you want to go to trial, how much is it going to cost me to get there? That's another thing I want to talk about.
We'll go in the back row over there.
I just have a couple of questions or things to add, just clarify for me. I actually just bought a house and goes through a little crack in my foundation and called some attorneys and such. I mean, long story short, the attorney fees, once we figured out how much it would cost, it was just pay it, and they got you for a few grand, and that was that. But what I've also noticed in the last couple of houses that I bought, and this is where I say I've never seen this, but every contract I go into, it's a binding mediation contract, meaning it's never going to get to a court where attorneys can run up fees, because it's binding. You're going to stay with the mediator, and what he says is going to be the end.
So are you drafting your own contracts?
No, that's from a realtor.
Are you talking about a house?
Yeah.
Okay. Now, if you're buying a house, you should insist on using the CAR forms, the California Association of Realtor Standard Forms. They have a team of attorneys that look at those things and think of every little situation you could get into. And I know for a fact that those don't have binding mediation. You have to go to mediation, but it's not binding.
Why wouldn't, as a buyer and a seller, why wouldn't I want binding so I'm immediately avoiding these high lawyer fees, and I know we're going to get this settled, one way or another?
Well, I mean, what happens if you're not happy with how the mediator comes out?
Well, that could be, you know, the same scenario that the end facing a
Again,
lawsuit.
it's a business decision. There's nothing wrong with that. There's a reason we have arbitration. That's why the country favors arbitration, because it's supposed to be faster and cheaper than a trial. It's not, but it's supposed to. Same thing with binding mediation. If you're putting all of your cards in the mediator, and whatever he says goes. Now that mediator might not follow the law, and you think he did something wrong. What's binding? You've agreed to that. So again, it does save a lot of costs down the road if you're trying to litigate, but you're taking the risk there that you're waiving your right to go to a jury and present the facts and make sure they follow the law and appeal all that. So again, it's a business decision.
Right.
Yeah.
The other quick aspect, when you're doing flips and such, and you're making even these, light rehabs, technically all this stuff is supposed to be permitted no matter what. And who actually, when they're doing flips, is actually going to the city, pulling the permits, waiting that time, paying these big fees. So when it comes to suing and such, isn't that really kind of like a huge area, gray area where the buyers can really, pull havoc on you because you didn't follow the exact details of like, hey, you changed this flooring and it speaks a little now, and you didn't disclose that in the disclosures, and it's so minor, but you can really.
So the question is, what's the buyer's protection when when work was done without a permit?
Or seller per se.
Yeah, or a
Coming
seller.
From the flip side, I want to change some carpet out, but now I've got to go to, pay a permit and do all that for something minuscule, but it could, you get the picky person that wants to make your life hell.
Now, I think you got to remember, if you're flipping houses, it's a business, and when you're doing it for a living, the law kind of thinks of you as a sophisticated party. You know what you're doing. And when you have a business like that, the business is supposed to follow the rules. You're supposed to pull the proper permits. You're supposed to get all that done. I know it's annoying. I know it holds up your project. It eats into your profitability. But when you don't follow the law, sure, you could disclose that. We did this without permits. You can do that. You have to disclose that.
Right.
Again, it is buyer beware. You can get away with it. But if you're flipping homes, you're a business. So potentially the city could come after your business, I would think, and say, hey, you're supposed to pull permits for this stuff. And if you do get sued by the buyer for not getting the permits, because say the city now comes to the property and forces them to demolish everything you just did.
Red flag.
Yeah, they can red flag the house. They can, basically what the city likes to do, or tries to do, is they'll come in and say, you built this without a permit, demolish it, get the permits, rebuild it. You're gonna have a very unhappy buyer. And even if you might be in the right, that's a lawsuit. That's a lawsuit that you're gonna have to defend. It's gonna cost you a lot of money. So you gotta remember that. So I don't know many flippers that forego permits. Maybe Rick, you do, because you're more in the transactional part of this.
I've seen a couple here and there that do stuff without permits.
I would say most of them pull, a good amount, but there's always
Yeah,
side projects and things going on that.
You always have a general remodel permit. Like that's almost like a default for a lot of developers who are just fixing, because you can just do a general remodel, and it's like, what does that even include? But that can include a good chunk of work to be done. So yeah, most developers and flippers that I've seen, they do pull permits, because it does give them that layer of protection. Should a buyer come back and saying, well, this was done incorrectly, if I'm the seller, I'm like, I'm sorry, the city saw this, they signed off on it, you're on your own.
And you can't sue the city because they're immune.
One more quick thing and then I'm done. I've never heard anybody say that JADU and ADU did not have to be owner occupied. Been to a few ADU conferences and it's always has to be owner occupied. Where can I find this information that I don't have to go there?
Well, you can find it online. Hold on. But I mean, ultimately, you could just read the statutes. Let me find it in my little list here.
Like the city of Oceanside had a meeting for ADUs, and they specifically said, the planners and everything that have to be occupied. So that's why I was just kind of like, whoa, trust me, I don't want to occupy. I'd love to throw another ADU on the house and make more money, but.
So SB 13 is the law about accessory dwelling units. It's only good for 5 years. It sunsets, meaning it's no longer law as of January 1st, 2025. And it prohibits conditional approval of an ADU based on the applicant being an owner applicant. What does that mean? I mean, my interpretation is that you don't have to, they can't deny you a permit for an ADU based on you not living on the property. That's kind of important because you can now put ADUs on multi-family dwellings. So you have a fourplex, you want to put an ADU on it, you can do that now. Yeah. So it's not just your house. So at least for the next 5 years, they can't make that a requirement. Now, after 5 years, as of 2025, unless they renew this law, they could just choose not to renew it, and now all of a sudden you have the city of LA saying you have to be owner occupied, and so your business kind of, you have to readjust.
Again, because I want to get to a couple more people.
Oh, sure.
Do you have something you want to add?
Same question about this.
Okay, go for it.
Does it mean that those who are able to build those within those 5 years, they can stay not owner occupied, and the new ones would have to be owner occupied?
Yeah, so this applies to approvals for ADUs.
So be going forward.
So going forward, so you wouldn't need a new approval in 5 years, but if you're going to build a new one after 5 years, you might need to be owner occupied to do that.
So we'll take two more questions. So I know we'll go lean over here, and then we'll go Rick back there.
Yes, I have two questions. The first one is short. So you mentioned that if you're looking for like a roommate, you don't need to follow this discrimination, and you can use your chat phone if you want to live with this person. Does the same thing applies if you live in one of the units of the unit house, or if it's ADU?
So
Okay, so you can't discriminate, period. If you're living in the house and you're talking about a roommate where they're living within your same living space, yeah, you can say, well, I just didn't mesh with that person. Our personalities didn't work out. You can't do that if they're not living in your unit. So if you've got an ADU, you have to follow the same laws as if you're renting an apartment. You can't discriminate based on those protected classes. And you shouldn't. I mean, you shouldn't do that. You discriminate on whether they can afford to pay, what you're asking for it. But you should treat everybody the same when you're renting any property out.
Okay. And the second question is on the deposit in case of the eviction, right? So basically, obviously, you don't return them the deposit properly if they leave more than a month or so while you have this eviction process, but also you incur the loss of rent, and maybe they're pissed off and they're in the apartment. And so can you claim some money from the people who were being evicted, or like how does that work? Do you have to go to court and you get your attorney and you spend $100,000 and they pay?
And you talk about the deposit that they gave right when they wrote the.
Yeah, so it probably won't cover all the costs you have after. So can you
Go after for more. So in other words, just so I understand, so if let's say the deposit was $3,000, but they did $5,000 worth of damage, how do you get that $2,000?
Well, that question, is that what you were asking?
plus loss of
Okay.
rent as well.
Plus loss of rent.
So yeah, when somebody breaches your lease and say they cause property damage, like Rick just said, you can try to go after them, but you got to remember these are regular people. They're not gonna have, they might not have the money, and so you're suing them over a couple $1,000s, and you might you're gonna spend more than that on an attorney. You could go to small claims and try to get it that way, and then you have a judgment against them, and then you got to collect the judgment somehow. The judgment is just a piece of paper. So you got to think about it in terms of business decisions. Is it worth the money? You have insurance, for instance. Maybe insurance will cover that. If you don't want to use insurance, just a couple $1,000s to you're gonna repaint, redo the carpet anyway to get a new tenant in there, usually. So you kind of budget for that kind of thing. If it's a big amount, where you see people suing for loss of rent, it's usually more commercial properties because that's a lot of money. But here, you're talking about a month of rent, maybe 2 months. You're not, it might not be worth the attorney's fees to do that. So can you withhold the security deposit? Say they gave a certain security deposit and you didn't use all of it up to fix the property. I would actually have to go look at that. I don't want to give you like a definitive answer on that just on the spot. In commercial leases, yes. In residential, I have to look at it again. But usually that's more for property damage, secure the property, not so much the rent. A lot of times, you can work out a deal with the tenant, that they forego return of that if they move out, something like that. It's all, you can settle for any terms that the tenant's willing to settle on. But in terms of a lawsuit, it might not even be worth your time suing them for it.
So we'll go with the last question, which was Rick, the one with the great name.
If you're new to landlording, is there like a boilerplate lease you could point us to, or would you always suggest consulting with a lawyer before you do your first lease?
I mean, it just depends on what you're leasing. If it's just one unit, the California Association of Realtors does have a form residential income property lease agreement, right?
Yeah.
And so you could just use that because like I said, it has more than you need because it covers so many scenarios. So usually you can start from that and maybe kind of hone down just the terms that are important to you.
Okay. Well, so we can ask after. So, has everyone who wanted to be in the raffle entered? No. So let's take a couple minutes, enter, and then we'll see who gets the free hour. Thank you so much, Mark, for coming. I really appreciate it. So I'll give him a round of applause.
Hey everyone, hopefully you liked the video. If so, please don't forget to give it a like, maybe show some love in the comments. Also don't forget to subscribe. We do have other videos posted. Please go ahead and watch them, enjoy them. They'll be posted somewhere here. Feel free to click or just view the channel in general. Thank you guys so much. I'll see you next week.